All rise, please. Hear. All persons have anything to do before the honor, the justices of the appeals court, now sit and lawsuit within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts, court of law.
Good afternoon, everyone. We have one case on for this afternoon, May 6, 2025. I'm your panel chief, Judge Vicki Henry. On my right, I'm delighted to be joined by Judge Shin, and on my left by Judge Brennan. The case is 2024 P530, Commonwealth versus McGrath. Each side has 15 minutes, and for better or for worse in the appeals court, there's no rebuttal. I'm just also going to mention that I'm cold, so if you see me looking like stern and I'm listening to you, I'm just really cold. And so with that, we can begin. We can hear from Mr. Baranowski.
Good afternoon, Your Honors, and may it please the Court. Brad Baranowski, he, him, his, on behalf of the appellant, Jill McGrath. As Your Honors know, this appeal raises a set of issues from Ms. McGrath's conviction for breaking and entering a building during the daytime with intent to commit a misdemeanor therein. I'd like to focus the bulk of the discussion today on the sufficiency issue. And here, really, there are kind of three key points to be made that all kind of tie around timing and the timing set of issues related to timing on that conviction. The first, as Your Honors know, the Commonwealth has to prove each element of the crime beyond a reasonable doubt. And here on the breaking and entering charge, the Commonwealth failed to do so with regards to intent. And again, timing here is key. For the conviction to stand, Ms. McGrath needed to intend to steal Mrs. LaPlante's dog at the time of the breaking and entering, not either once inside the building or once outside of the building. That didn't happen here. If Mrs. McGrath formed the intent to steal Mrs. LaPlante's dog, then the evidence shows at best that she did so after the breaking and entering had ended.
What about the testimony about your client threatening to take the dog, which came in substantively? I know you have that as part of your ineffective assistance, but it was evidence.
Yeah, so I think other than, there are kind of two issues there. One, I can tie in Justice Brennan to the timing issue. There's also, we think Commonwealth versus Green controls there, that was hearsay, and that Commonwealth versus Green.
How do we know that the complainant wasn't there when it was said? It doesn't say my husband told me that. It just said she threatened my husband that she was going to take the dog.
With all due respect, we think the most natural reading of the transcript is that.
Is that the standard, the most natural reading?
Well, if your honors don't find this convincing, there is a fallback position on this, which goes to the timing issue that I wanted to raise on that statement. The statement itself doesn't say anything in terms of when the alleged threat was made. It just says once Ms. McGrath told Mr. LaPlante that she had said this. We know that basically it couldn't have been sooner than 6 days prior to the event because unfortunately Mr. LaPlante died. And it probably happened at the earliest in December of 2021, which is about 10 months before, because that's when Miss McGrath, gave the dog to the LaPlantes. So we have a 10-month window that statement could have happened in, but we don't know at all when that happened. And so
when was your client removed from the home? Because that might narrow that down some.
In March of March of the same year of the actual event, so March of 2022, if memory serves me correct. Yeah, so there could possibly be within that window as well. But again, we don't know, and the fact finder had to speculate on the timing. And in terms of understanding whether this was not too remote in time to indicate Miss McGrath's intent on the breaking and entering, there just wasn't sufficient evidence here. And I would just note that this could have been solved relatively easily by the Commonwealth just asking a follow-up question of Mrs. LaPlante, given this was their witness, but they didn't do that, and so we just don't have.
But there wasn't an objection, was there?
There was no. Sorry, I didn't.
There was no objection, was there?
There was no objection, and of course that would go to, which I'm happy to go to, the ineffective assistance claim I raised on direct, but there was not. The trial counsel did not raise that as an objection.
Before you get there. Is it your position that the Commonwealth is required, without any motion for bill of particulars, to particularize the misdemeanor in this case?
I mean, so the Commonwealth can't raise here, they did raise a new theory that they're trying to base this upon. Are you,
Yeah, I mean, why was the judge not free to find sufficient evidence either of larceny of the dog or trespass?
A couple things. So let me just take the procedural component before I get to the merit. So in the procedural component, one that would be in tension with some of the SJC's case law. So for example, Commonwealth versus Lee, which we cite in the opening brief, there's a footnote there, footnote 3, in which there was also a breaking and entering with an intent there to commit a felony. But
well, it is a difference, I think. But go ahead.
Yeah, but the SJC said that because the Commonwealth was trying to raise new theories on appeal to try and basically save the conviction on appeal, they were stuck with the theories that they had litigated on and on below. And so too here, I think, that the Commonwealth is stuck with the theories on which that they litigated this. And we know that they didn't litigate this on criminal trespass, Justice Brennan, because the original, for two reasons. One, the Commonwealth's closing doesn't mention that at all, and there was no opening. But two, maybe more fundamentally, is Ms. McGrath was originally charged with breaking and entering with intent to commit a felony, and criminal trespass is a misdemeanor. And so this was all, and if you read more general you, in the transcript, there's a lot of testimony about trying to prove the worth of the dog, essentially to get it up to the $1,600 for the felony there. So the whole case is litigated as that. And so I think that would be, I think there would be definitely some tension on that as well. But if I may go back to...
So how do you respond to the Commonwealth's reliance on Rogan?
On Rogan?
Yeah.
That
they don't have to prove any particular misdemeanor. They don't even have to specify the misdemeanor.
Again, I think that this is, I go back to what I was saying with Justice Brennan. I do think this is in tension with the fact that the Commonwealth has to articulate is stuck basically with the theory that they raise below that on appeal. And so I think insofar as we want to transport the bill of particular type case law into this, I think that might start to run into, like, say, the Commonwealth versus Lee line of cases. And so I would just say that's the more instructive line of cases here, that, again, the Commonwealth is basically stuck with the theory that they litigate below once they get to appeal. If I may, though,
Can I just follow that with one more question?
Sure.
If we disagree with you as a legal matter,
yes,
do you concede that there was sufficient evidence to support a breaking and entering with the intent to commit a trespass?
We do not concede that, and I'm happy to walk through a bit in terms of what the theory there would be. So I think in terms of, it's a timing issue in terms of when Ms. McGrath is told she cannot come in. And the Commonwealth has pointed in the transcript to statements that, I won't go through all the different issues, but the more fundamental issue is that those statements are when she's already in the building, and it goes back to kind of the core point I was going to make with, just if we stick with the idea that the dog is the larceny of the dog is the predicate. Intended misdemeanor. That's all when she's already in. And so, yes, at that point, we'd have an issue that she needs to go, but it doesn't speak to the intent she had coming in, which again is, from the record, pretty clearly to get coats that belong to her.
Yeah, on the trespass, I don't understand that, because if you enter without right, that's a trespass. She knew she didn't have a right to enter. She didn't have she somehow got keys, but the door was locked. And then if you stay after you've been forbidden to do so, and, we all hear on the 911 call that Ms. LaPlante says, get out, and she says she's going to get these coats, so that seems like that's her mission. Why can't the judge infer that's what her plan was?
I think for a couple of reasons, Justice Henry. I think one is we do have her testimony, unrebutted testimony, that she had permission to be there. But second, again, the timing issue is that she comes there to get the coats, as again the 911 call makes clear, and that's when she's told told to leave. And so I think, again, it goes to what's her intent at that moment. Obviously, if you disagree with me on that, then I'm...
Right, she was told to leave, and she proceeded to go ahead and get the coats, right?
Well, Justice Shen, my understanding of the record is that she was already in the house at that point.
That's right, but if you're in the house and you're forbidden to remain, and you remain anyway, that's also a trespass, right?
Right, but the intent, the issue here is figuring out what the intent was at the time of when she began the breaking and entering, not when she's in the house and not when she's outside
Why is
the house.
that?
I think that's just what the case law establishes in cases like POF, that you have to be looking at what the intent is at the moment of the breaking and entering. And in part, as the SJC has said,
Oh,
I
for
think
the breaking and entering, I see.
Let me ask you then this. Why was the judge not, again, in the light most favorable to the Commonwealth, free to infer that her intention was, I'm going in to get my coats no matter what. I don't care if she says, come in, don't come in, whatever it may be. I'm supposed to be here, not supposed to be here. I'm just going to go in and get my coats. Isn't that really an inference that a reasonable fact finder could draw, that at the moment that she went and got apparently, if you inferred, the key from the truck to unlock the door that was locked, and then entered the house, her intent was to go into that house where she was going to stay until she accomplished her purpose?
Again, I think we'd have to point to some more things in the record that specifically substantiate that inference to make it, obviously not more on the speculative end, more on the reasonable end. And obviously, our position is that it's just not there, and so that's on the criminal trespass. Insofar as you get there, again, I would say that our top line is the procedural issue, that this is a new theory, and I would just look to footnote 3 in Commonwealth versus Lee to kind of be the easiest off-ramp on this. But even so, I still
I guess
think...
my question is this. Isn't it inherently a B&E with intent to commit a misdemeanor if you enter someone else's home where you don't belong, regardless? I mean, that intent can be inferred.
I think, though, you have to just disaggregate them, because then there's really not any... The intent, I'm not sure the intent prong is doing much work on that.
Fair enough.
On that articulation.
I thought your position was that the husband gave her permission.
That was where I was starting at with Justice Henry, but I just was, I guess...
Well, so correct me if I'm wrong. I thought her testimony was that the husband gave her permission to enter the garage and that he would be there to supervise if she wanted to go into the house to get anything. Is there a testimony other than that?
I agree with you, Justice Shin, that she does just say that it's that, and so the...
Okay, so he never gave her permission to enter the house without him there. He wasn't there. The owner who was there had previously had her arrested and tried to get a restraining order, never welcomed her back. She didn't answer the door when she knocked, and then she goes and gets the keys and opens the door. I mean, why isn't that enough to support a trespass?
Again, I think that it has, probably in the context of this case is key. Not only does she's testified that she has permission to come there, and then she comes there on one of the days that she said.
Her testimony was specifically, he would be there to supervise if she wanted to enter the house, but he obviously was not there, right? So she didn't have permission.
Well, I was going to say in terms of the sequence of events, I think kind of follows somewhat naturally from that, her arriving on one of the 2 days, so I think it was a Wednesday and a Thursday in particular, that she was said that she was allowed to be there, and trying to find out, the person that could let her in. I think that's probably the kind of the line we would draw here, but obviously the court may disagree on that.
Okay.
So what's the line you're drawing?
Oh, in terms of, to Justice Shin's point, that why isn't it that, so long as I understand it correctly, so why isn't it that the fact that she just testifies that she has permission to come to the garage, and then, she proceeds to knock and then go in the house? Why is the garage testimony not dispositive? I think, if I was understanding Justice Shin's point correctly, why isn't that basically dispositively bad for my side? And again, I was saying that I think in terms of the sequence of events here, I think it makes sense that she has permission on a Wednesday or Thursday. She comes on one of those days. She knocks and keeps knocking. And again, she had been trying to get this stuff for some time. So it makes sense that at that point, I think the natural inference is that she wants to get in and she goes in the house. I would say just
But
if
I thought the whole point was you're claiming she had permission to go in the house, and I see nothing that says she had permission to go in the house.
I'm saying that she had permission to be on the property. I'm saying, and if at some point in the brief said something beyond that, I will correct the record for that. But the testimony that she had permission to be on the property, and again, mea culpa if the brief somehow overstated that. I will just say briefly on if so far as the court does go the direction of just looking at the series of events related to the dog. Again, I would just point out that I think it's, even though I know you've all read the record and I don't want to just go through it, I do think the sequence matters insofar as, Ms. McGrath goes in the house, Mrs. LaPlante testifies that she goes in to get, that Ms. McGrath goes in to get coats, and that the dog just runs out. There's no evidence in the record that Ms. McGrath tried to coax the dog out or had a leash or anything like that. So in terms of the on the day of evidence, we just have the testimony of Mrs. LaPlante saying that the dog runs out after Ms. McGrath, which again, the fact that what happens to the dog afterwards, we're not contesting the ultimate larceny or even the assault and battery. Obviously, this situation escalated, but the escalation I think goes to the fact that things can happen kind of on the heat of the moment, and that's kind of our top line position on the dog.
Okay.
If there are no further questions, I'd rest on my brief. Thank you.
Thank you very much. We'll hear from the Commonwealth.
Good afternoon, Ellen Lazar for the Commonwealth. This court should affirm the defendant's conviction of breaking and entering with the intent to commit a misdemeanor because the evidence was sufficient to support the conviction. The defendant challenges the sufficiency of the evidence only as to whether the Commonwealth proved that she entered the victim's home with the intent to commit a misdemeanor. The cases make clear that the Commonwealth was not required to designate a particular misdemeanor that the defendant...
But he's right that footnote 3 in the Commonwealth versus Lee case says that if you didn't advance a theory at trial, you're not presenting it on appeal. And that does kind of seem like basic fairness, doesn't it?
So, Your Honor, two things about that. First of all, I would say that I disagree that the Commonwealth advanced a particular misdemeanor. If you look at the prosecutor's argument, as far as I read it, he does not say, this is the misdemeanor that well, first of all, she was charged with breaking and entering with intent to commit a felony, not a misdemeanor. The judge convicted her of the lesser included offense. But the prosecutor doesn't assert this is the crime that we allege she intended to commit at the time she entered. He really just argues the facts, and he does focus quite a bit on the theft of the dog, but she was also charged with larceny of the dog. So I disagree that the Commonwealth, that the prosecutor locked the Commonwealth into one particular theory as to what that misdemeanor was.
So what does Lee mean in footnote 3 when it says, and I'm quoting, arguments on appeal must be based on the theories on which the Commonwealth presented the case at trial?
That if you look at both the evidence and the argument, that both the evidence and the argument in this case, it's the Commonwealth's position that both the evidence and the argument could support a conviction of breaking and entering with intent to commit either the misdemeanor of larceny under 1200 or the misdemeanor of criminal trespass.
Did the word trespass come up at trial?
The word trespass did not, but as I recall, I didn't memorize the closing argument, but frankly, I'm not sure how much the prosecutor even used the word larceny. He was talking about the facts, and you could infer from the facts that she took the victim's dog. But again, the defendant was charged with larceny, and the crime that the defendant entered with the intent to commit does not have to be a charged crime. It can be an uncharged crime and an unspecified crime. And it's the Commonwealth's position here that the evidence supported a verdict.
Right, but I guess that's my fundamental fairness question. I get that it can be unspecified, but can it first be specified on appeal?
Yes.
And so Lee is wrong? You think we should just not follow the SJC on that one? Or am I misreading it?
Well, forgive me, I don't recall the exact wording of the footnote in Lee. I think my understanding is the gist of it is that you can't simply change the theory to a different specified crime. If you've specified one crime below, you can't just specify a new crime on appeal. But I believe here that the Commonwealth did not specify a crime that the defendant was alleged to have intended to commit upon
Go
entry.
back to the fundamental fairness of that one. If it wasn't the dog and you never said the word trespass, why is that fair? That seems very unfair.
Well, to take a step.
I get it, in
Yes.
ABDW, if the indictment says, to wit a shod foot, and then the testimony at trial is a knife, we are okay with that. But here, I don't think anybody says the word trespass.
No one says the word trespass, Your Honor, but there's certainly evidence about breaking and entering, and whether the defendant has the right or has been given permission to be on the premises. And there's certainly debate in the evidence about whether that's so. So even though they don't use the word trespass, certainly the evidence goes to the element of whether the defendant has been given any permission to be in the house in the first place.
So if this had been a jury trial, as a practical matter, there would have to have been some sort of underlying misdemeanor specified or felony, right?
Actually, I don't believe that that's so. I believe that the cases do stand for the proposition that it can be given to the jury without the judge specifying what
There could be more than one, but how is the jury supposed to determine whether something's an underlying felony without being instructed about what constitutes the felony?
Yes, I think that I have seen cases where a judge might instruct that, in this particular case, I do instruct you as a matter of law that X crime is a felony.
I mean, that, as a practical matter, I think that would have to be the case, right? So as a jury waive, what do we do then? I mean, Lee was also jury waived, wasn't it?
Mm-hmm.
So
Well,
we just assume the judge would take into account all possible misdemeanors.
yes, that it's presumed that a judge knows the law, that he instructed himself properly on the law, and that he could find, there's no requirement, certainly, that the judge announce what misdemeanor he found the defendant entered with an intent to commit. And the cases that I cite, Rogan and Scott, both stand for that proposition, that the Commonwealth does not have to designate a particular crime and the judge doesn't have to announce the particular crime. But it's the Commonwealth's position in any event that there was sufficient evidence both as to entering with the intent to steal the dog and entering with the intent to commit a criminal trespass. As to the dog, the evidence showed that the defendant entered the home and left with the dog. And I cite two cases, Pereira and Lazier, I'm not sure how to pronounce that, but that state that you can infer from the actual commission of the crime that the person entered with the intent to commit the crime. That in and of itself is not enough, but it's one factor to be considered in determining whether the defendant entered with that intent. In addition,
You're saying that if she was standing on the doorstep without the intent to take the dog, but she went in and then she saw the dog and said that we can still affirm a conviction because she did in fact take the dog.
no, that's not what I'm saying. I agree that the defendant has to have the intent to commit the crime at the time she does the breaking and entering.
So what's the evidence? What's the best evidence in the light most favorable to the Commonwealth from which the judge could have inferred that she had that intent when she went in?
Right. So what I was saying is that the actual theft of the dog is one factor that the court can consider in deciding whether the evidence was sufficient that she entered with the intent to do it. It's not my argument that the fact that she stole the dog in and of itself is enough, but it is one factor.
What are the other factors? There you
Yes. In addition to that, the victim reported that when she confronted the defendant and demanded the dog back, the defendant said, "I'm not going to give you your dog back till you give me my stuff." That's another factor that the court could consider with regard to her intent. She wanted her things, she was angry she didn't have them, she was going to take the dog until she got her stuff. And third, the victim testified, as Your Honor noted, that the defendant had previously threatened the victim's husband that she would take the dog away. And even though the defendant now claims that that evidence was inadmissible hearsay and that counsel was ineffective for failing to object to it, because there was no objection, that evidence is considered as part of the analysis of whether the evidence was sufficient.
I thought her statement that she'd give the dog back if she got her stuff was made after she had already left the house and the dog had followed her out.
Yes, the statement was made
Yeah.
once she was outside and the victim was demanding the dog back. The defendant said, "I'll give you your dog when you give me my stuff." But it's still part of the evidence that was before the judge in considering what the defendant's intent was when she went to the house. So given that she does ultimately take the dog, she makes a statement about, "I'll give you your dog when you give me my stuff," and that there had been a prior threat to take the dog, it's the Commonwealth's position that the evidence was sufficient, that she entered with the intent to commit the larceny. And as the court is aware, it's also the Commonwealth's position that the evidence was sufficient to support the verdict that she entered with the intent to commit
She
a
didn't
criminal
take the dog
trespass.
inside the house. She went outside already, and then the dog followed her out. That seems to me to be pretty strong evidence she did not have the intent when she entered.
Well, Your Honor, simply because she didn't pick up the dog and carry it outside doesn't mean that she didn't enter with the intent to take the dog. The testimony was that, she had lived in the house. She knew this dog knew her. This dog was actually the, I wanted to say daughter, but puppy of the defendant's own dog. And so when she went in, this dog followed her right out. And according to the victim, went in. By the time the victim got outside, the victim's dog is already in the defendant's car. So the victim doesn't testify as to how the dog got in the car. It's the defendant's testimony where she says, oh, they were playing, they were jumping in and out. But she also says she never took the dog. She also says she never went in the house. So, and obviously this is viewed in the light most favorable to the Commonwealth.
Legally, is there a distinction from your perspective between if the intent to commit a felony in terms of notice and in terms of what the Commonwealth is required to, where we are on appeal if your theory of the case is different as opposed to a misdemeanor? In other words, you get my question? Not terribly well articulated?
Sorry, I don't understand.
No, let me try it again. So I think I understand your argument to be that if it's a misdemeanor, you don't have to specify. Generally speaking, for a felony, you're required to specify what the felony is. Is that not correct?
I actually don't believe that you are, and I'm only saying this because I remember having an appeal many years ago myself where it wasn't specified, and I can, if with the court's permission, send a letter to the court to address that.
And so in your position, as long as there is some felony that a fact finder could rationally find, that's sufficient and it doesn't require, it's really a notice issue, not a proof issue.
Yes, well, I think it's both in the sense that, I mean, again, the cases clearly say it doesn't have to be specified. It doesn't have to be specified by the Commonwealth. It doesn't have to be specified by the judge. The judge rightly denied a motion for bill of particulars in one of the cases. So I think that there is notice in the fact that the person is charged with breaking and entering with intent to commit a felony or a misdemeanor, and obviously they know what the evidence is to the extent that, they have notice of.
What's your best case or case on these issues?
Yes, so, well, Rogan and Scott are the two cases I cite with regard to the fact that you don't have to.
Spell Rogan, because I'm not seeing that in your table of authority.
It's Rogan versus Commonwealth.
Okay, all right.
Yes.
Scott is the appeals court case you cite in your brief?
Yes, Scott is 71 Mass Appeals Court, and this particular piece of it is at page 604 in footnote 8. And in Rogan versus Commonwealth, I believe it's 415 Mass at 379. And with the court's permission, I could send a letter with regard to the felony piece of not even having to specify.
Well, I mean, I'm still stuck on Lee, which was a bench trial and does clearly say the Commonwealth had a particular theory at trial, and they've argued new theories on appeal, and that doesn't work. So I don't understand how that squares up with Rogan and Scott. Also, is there such a thing as felony trespass? Because, again, I'm back on notice, right? And the defendant was charged with breaking and entering during the daytime to commit a felony.
Yes, Your Honor. So again, I disagree that the Commonwealth specified below a
I don't
particular...
think it works that you can specify nothing, and so then you can pick anything on appeal. If you, the SJC seems to be saying you can't come up with something new. And I guess you're saying, well, they're arguing based on evidence, but those would all these theories also would have been based on evidence. I mean, I can't imagine the Commonwealth was arguing a theory that had no basis in the record.
No, Your Honor, but if you read the closing argument of the prosecutor, at no time does he say, Your Honor, we ask you to convict of this crime. It was breaking and entering with intent to commit X. There was no particular crime asserted to be the crime that fulfilled that element.
He doesn't say much, really.
It's
Well,
a
but
very short...
There is in the application for a criminal complaint, and it's taking the dog.
Oh, if that's the case, Your Honor, I apologize because I missed that myself, if that's what's specified as the crime. Although, again, the Commonwealth's theory was that, or not the Commonwealth's theory, the charge was intent to commit a felony, and the judge ends up...
I understand, but Record Appendix 18 says take the dog.
Then I apologize, Your Honor, if I am incorrect in my argument because
that make a
I
difference?
don't
So
recall that.
If it is alleged in the application for complaint that it was the dog, then is it your position that the fact finder cannot find any lesser included but for something that's related to the dog, or is the judge still free to find any misdemeanor that was supported by the evidence?
I do think that the judge could still find the misdemeanor of intent to commit a criminal trespass because that was supported by the evidence that was before the judge, and he, of course, could choose what he credited and did not credit. But with the court's permission, I would send a letter addressing this more fully, and I
I take
apologize.
back what I said before. Note 8 of Scott does seem to say that even if it's a jury trial, the jury doesn't have to be instructed about the elements of the underlying misdemeanor. So are you reading these cases together, including Lee, to mean that if the Commonwealth locks itself into a theory at trial, they can't raise a new theory on appeal, but if they don't specify anything, they can raise anything on appeal? Is that really what it boils down to?
Well, I mean, that appears to be, if you read the cases together, that if nothing is specified, then anything that is supported by the evidence is a permissible ground on which to sustain the conviction, but that if the Commonwealth does specify something, that a new theory cannot be raised on appeal.
All right, I think a letter might be helpful.
All right. Thank you.
Any other questions?
Oh, no, good.
All right, with that, the case is submitted. I want to thank our staff for their assistance in putting on today's sitting.